Supreme Court allowed the civil appeals in the matter of PRABHAVATHI and others versus Managing Director, Bangalore Metropolitan Transport Corporation, in the terms that impugned award dated 12th December 2017, passed by additional small cause and additional MACT Bangalore as modified by High Court. The impugned order dated 1st October 2020 stands modified and interest is to be paid as awarded by the tribunal. The brief facts giving rise to these appeals were that on 6 June 2016, the deceased, namely Bubalan, aged 38 years, was traveling on his motorcycle from Krupanidhi Junction towards Madiwala. The driver of BMTC bus bearing registration number KA01F9555 collided with the deceased, driving his vehicle in a rash and negligent manner, resulting in death on the spot due to grievous injuries. The appellant filed a claim petition before the tribunal seeking compensation of 3 lakhs, submitting therein that the deceased was only earning member of family working as an executive in housekeeping department at Royal Orchid Hotel, Old Airport, and earning up to 70,000 per month. Tribunal, after considering last drawn salary of deceased, awarded appellant's amount of 75 lakh 97,000 60 rupees along with 9% interest per annum and held that accident occurred due to rash and negligent act of driver of BMTC bus. Being aggrieved with the amount of compensation awarded, both parties filed appeal for High Court. Appellant challenged the same on ground the tribunal incorrectly determined the monthly income of deceased as 62,725, whereas proven income as per bank statement should be 70,000 per month. On the other hand, respondent challenged assessment on the ground there was no negligence on the part of driver of bus. High Court, via impugned order dated 1st October, allowed appeal and determined contributory negligence as 75% on driver of bus, 25% on deceased by relying upon statements and documentary evidence on record and came to conclusion that accident occurred due to rash and negligent driving of both deceased and driver of offending vehicle as both were driving at high speed and further assessed monthly income of deceased at 50,000 per month and awarded enhanced amount of 77 lakh 50,000 at 6% interest per annum. Claimant appellant was now before Supreme Court. The significant point raised by appellant was that High Court wrongly assessed contributory negligence of deceased to extent of 25%. Supreme Court said that in our considered view, the contributory negligence taken by High Court at 25% of deceased is erroneous. We advert to the principle laid down in Jiju Kuruvilla versus Kunju Jamma Mohan, where it was held that in absence of any direct or corroborative evidence on record, it cannot be assumed that accident occurred due to rash and negligent driving of both vehicles. This exposition came to be followed in Kumari Kiran versus Sajjan Singh. In present case, therefore, on allegation simpliciter, it cannot be presumed that accident occurred due to rash and negligent driving of both vehicles for having driven at higher speeds. It is settled law. Under the Motor Vehicles Act 1988, it is established that in compensation cases, strict rules of evidence used in criminal trials do not apply. Instead, standard of proof is based on preponderance of probability. The exposition came to be reiterated in Rajbati alias Rajjo and others versus United India Insurance Company and others. It is well settled that Motor Vehicles Act 1988 is a beneficial piece of legislation and as such, while dealing with compensation cases, once actual occurrence of accident has been established, tribunal's role would be to award just and fair compensation. As held by court in Sunita and Kusumlata case, strict rules of evidence as applicable in criminal trial are not applicable in motor accident compensation cases. That is to say, standard of proof to be borne in mind must be of preponderance of probability and not strict standard of proof beyond all reasonable doubt, which is followed in criminal cases. The compensation now payable to the claimant appellant was recalculated as rupees 1 crore 20 lakh 84,925 from 77 lakh 50,000 that was given by High Court and 75 lakhs 97,060 that was given by tribunal and 30 lakh that was demanded by the appellant in the beginning.